Looks like we are live to Facebook.
Ahmed, would you want to text Commissioner Johnson to see if he's having difficulties?
Yes, I will do that right now, Mayor.
All right, Lana, I'm going to send host back to you. Thanks all.
Thank you, Dave.
Thank you.
Welcome.
He is joining in a few minutes, Mayor.
Very good. And we will go ahead and get started. Again, welcome everyone. I think this is our 8th meeting of the Community and Police Relations Task Force. And we have 2 topics this evening or afternoon. The first is Doug Bach, County Administrator, will give us a overview, kind of an update on the selection process, where we are in the selection process for a new police chief. And then following that, we will have a presentation on the topic of qualified immunity. And this, we were requested to take up qualified immunity, I think by Dr. Hill, but also by Commissioner Townsend. So we will hear, we have a city attorney here to kind of just run through what qualified immunity is and isn't. But if you would just take a chance, I would ask that you introduce yourself. We'll start with Sheriff Ash.
Yes, Don Ash, Wyandotte County Sheriff.
Dr. Hill.
Sorry about that. Good afternoon. Evelyn Hill with Avenue of Life. I'm the Director of Equity and Justice. Thank you. Glad to be here.
Thank you. Monsignor.
Monsignor Stuart Swetland, I'm the president of Donley College.
Ms. Castor.
Yeah, good afternoon. I'm Yureli Castor. I'm a graduate from Donley College and continuing my education at Rockhurst. Thank you.
Reverend Carter.
Yes, Tony Carter, pastor, Salem Baptist Church, Health Equity Task Force member, and Law Enforcement Advisory Board chairman.
Thank you. Mr. Smart.
Hello, Curtis Smart, graduated from the University of Kansas Medical Center, Public Health, and currently a recruiter for physicians, talent acquisitionist.
Thank you. And Commissioner Johnson.
Good afternoon, Commissioner Harold Johnson, District 4, Unified Government of Wyandotte County, Kansas City, Kansas.
Chief York.
Thank you, Mayor. Mike York, Interim Chief of Police, Kansas City, Kansas Police Department. Thank you.
Thank you. We have a few others who will show on the screen. The first is Dave Reno, Public Information Officer for the Unified Government Public Works Department, who's been with us throughout these meetings. Also, Ashley Hand, who is Communications Director for the Unified Government. Gordon Criswell, who recently retired from the Unified Government as Assistant County Administrator and is now graciously volunteering with my office to be part of my staff. So I want to thank Gordon publicly for that. Also, Anna Quimby, assistant in my office. And did I miss anyone? So that will take us now to Mr. Doug Bach, County Administrator, who will give us an update and a timeline for the selection process for a new police chief to replace Chief York, who is abandoning us to retirement.
He is that. Though he's a lot of good years of service before he gets to that point, before he steps on to the next adventure of his life. Good afternoon, everyone. I'm Doug Bach, County Administrator for the Unified Government. It's a pleasure to be here today and run through our chief process with you. This is one that's really gone on a long time. And, you know, maybe in the end, it's something that's been beneficial and in part of the evaluation process. It's one that started over a year ago. And then I held back on it as we came into the COVID issue and things that were surrounding that. And Chief York was gracious enough to continue to stay in, and it's his duty for the last year. It's his role for the last year. So I'm going to share my screen here and this up here, show you my little presentation I have for this. Is that on the screen for everybody?
No, we see your email, so you want to remove that.
Okay. No?
Yes, we see that.
Okay. All right, so if we all have it on now, this kind of shows a timeline. Is it breaking this out? Okay, here you go. Not the task that I do all the time. So as you come through it, as I mentioned, this is a process we started out over a year ago. In January of last year, kind of opened up a process that I was going to start soliciting input from the community as to where everybody was. And I will say a big thing for me was making sure I got more information from the public, probably than we had in previous processes of going through. I've been the county administrator since 2014. One of the first jobs I had as coming in was hiring the chief of police and going through the selection process and hiring Chief Ziegler. That process worked well for us, but in evaluating things that happened over those years, it seemed like I needed to solicit more community input before I started the process. So I opened up a session where I did some meetings with livable neighborhoods, community meetings with them. I let livable neighborhoods come in. They selected who they were bringing forward from neighborhood groups around, and they presented information to me to go through it. We also started a community survey, which was online from January until April. And then I established some internal listening sessions with the police department. This was really, I would say, a whole new thing where I just opened it up, did a solicitation through KCKPD online and let anybody that wanted to come forward to a session just with me, didn't have any command staff present, that they could talk about things they felt were working well with the department or issues or concerns they had. We did this process. I was going to do some other things during that time. However, as COVID came on, that really stopped the ability to do the in-person sessions. All these were in person. You couldn't do that. We weren't set up with the same type of technology we have now to get out there and start to access other people to provide their input. So I stopped that process. We focused on COVID, and that's where we were for many months. That kind of became a 7-day-a-week process for a long time. During that is when the mayor formed this task force. We obviously know the issues that came on in law enforcement last year. So from one aspect, I want to say I was thinking about and soliciting that input before a lot of things, before everything happened with what went on in 2020. your task force started to come together, as I talked to the mayor, understood this is you were soliciting different things that I would be valuable for me to get and put into my process and think about. Listen to your report that you all delivered in December of last year back to the commission. Gone back through that, listened to it again from what happened to kind of hear what a lot of the big issues or concerns were. Many things I recall from that were some of the enlightenment you all had by just understanding some of the things we were already doing. Also a big push from several of you that our need to communicate more about what we're doing. So that obviously lays back into where we are with the chief as we go forward about how we communicate with the public. So then in November 19th, I began posting the position again. I wanted to open it back up, listen to your task force presentation during that time frame, closed the posting in January, and also reopened in November the survey that I'd done last year so we could add to that, gave people a chance to add additional comments in for a couple of months. Coming into this year, I've gone through and taken candidate responses so they could put them through a couple different sessions where they did both written and video exercises. So we evaluated all the applications that came in, went through those resumes. Took a select group of that, went back to them, had them do the written responses back to us. They taped an interview that one of my staff members did with them, and then narrowed the list from there. Went through and created a group of semifinalists, and they did a virtual panel with some department heads, figure out how they were doing. We asked them a series of questions for them to respond to. From that, we were also doing a background check on all candidates. Very extensive. Well, I shouldn't say all. The ones we're looking at finalists. This is an example of what it is there. So I'm not showing up on camera, but 3-inch binder comes back up. It's about 2 candidates can fit into something like that. The amount of information we go through and try to get everything back from background checks with people we talk to, looking at all social media aspects, all their posting profiles, anything that they've essentially done or it's been online that we can find to find information about it. And from that, we come to a group that are finalists that will get selected to bring in for an assessment center that I'm planning for the middle of April. And then essentially the timeline takes me to May, hope to announce. So this is a snapshot of that calendar. What did I learn during that process? And this is a breakout of different things that came in from top priorities. If I look just at the survey pieces, we had 243 responses to that. Most were KCK residents that responded to this, over 90%. So that is our focus group, what we're trying to get. People really like how we do community policing. That came in strong. I will say that was also a big issue when I met with the neighborhood groups, and the download from them was that community policing is something that we could only do more of. And in fact, they would acknowledge how we have a strong commitment to this. We should spend more time engaging with the businesses, more with the residents and doing such, but they also recognize where we were in terms of staffing level. Community people push that we should have more officers out there and dedicate more of them toward community policing efforts. Outreach and engagement was hit high. Youth programs, as you can see, this kind of goes through different things we have. Enforcement, protection, those things ranked up there. But the survey also noted concerns with trust and transparency. And as you guys have gone through this, I think you see it's that where we fault in communication, well, that's directly correlates over to transparency. If you're not communicating with your public, it's hard to be as transparent with them as you want to. Diversity inclusion, an issue for us. Community involvement, increased visibility, crime reduction and prevention, and technology. So as you can see, there's some things that come out that'll kind of conflict with each other when you see high notes of this is something we need to work on, but then other people will say it's something we do quite well. It was kind of similar to that when I was talking to the community groups. I didn't necessarily ask this question, but I would be offered the insight of people would say that you definitely need somebody that has a good background, understanding the community that's from here, and I need to hire somebody from within the department. The next group I would meet with somebody would stress to me that it's time for some new blood to come in, and I bring somebody in from the outside and be there. So a lot of different positions on that, where we go to. We kind of summarized where we saw that some of the most comments were up here, as you see, continue efforts to reduce crime, technology, and then improving our community relations. We're in the number one item, which I think was consistent with one of the big items you all reported in your task force report. Next for me, as I've noted, what were our steps coming up to it? When we come into April, the task force, or not task force, the assessment center will be a series of roundtable sessions that we'll have with community groups. I will select a blue ribbon committee that will be part of this, that will watch the assessment center to be able to offer input back from it. There'll be simulated exercises that the candidates will have to go to. They will have one-on-one interviews with me. They'll have interviews that'll be done with, we'll bring in the FOP. I'll have a command officers group also come in and do interviews with them. And I'll have another neighborhood group come in, and they'll kind of do a little roundtable session with them as well. And that'll lead us up to a point where they will actually appear before the governing body. They'll have an opportunity to ask them some questions. At the conclusion or throughout those days that go on, I will take a download session from my blue ribbon committee to get their opinion, their feeling to how they reacted to everything that they went through in those simulated exercises. And then I'll also do some follow-up one-on-ones with my commissioners to get their thoughts on what they heard when they had an opportunity to meet the candidates. From all this, it'll give me the opportunity to put this together and select the person that is the best fit for our community, the best fit for our department going forward. And I hope to conclude that with an announcement of a new chief in May of this year. So that's really the summary of what I'll be planning to do and work through, Mayor, and that's my presentation this morning. I'm happy to answer any questions any of you have or take additional input.
Thank you, Mr. Bach. Questions or comments for Mr. Bach? Let me get everybody up, participants here. If you hit that, raise your hand or don't. Oh, Dr. Hill, there you go. Thank you.
Thank you for the presentation. Mr. Bach, definitely appreciated that. I just wondered, I have just noted that several police chiefs across the country have been fired during the George Floyd incident over the last several months. And I'm just wondering, is that something that you all are taking into consideration? I've seen different ones get hired in other cities, even though they were fired from where they were employed prior to now. So just kind of where are your thoughts in regards to those police chiefs who were fired in other cities and now, of course, are looking for new employment elsewhere, possibly Wyandotte County?
Dr. Hill, that's a great point in looking at it, because there are some people that are out there. There are some professionals in law enforcement that you'll see apply for jobs that to me look like they make a career out of moving from one chief job to another. I'm not going to say I would just discount somebody out from that perspective. It's not necessarily a strong suit. A lot of those people are ones I would classify as those you're seeing as major change agents, but you have to recognize, is that a change agent, the right type of person that you want to have come in? Specifically to those being fired, there's usually a reason behind why somebody's fired from a department. So that's one thing we dug into. I don't have any of those candidates that have moved through that are in consideration for my finalist group to be moving forward. So I do give a lot of strong interest in looking back at my internal candidates that came into the process to vet them through it. I don't know if you're aware, I mean, our history has been one where we've always hired internally, though I'm not saying that is what I have to do. In fact, I've made it clear that I am looking strongly. We hired I think I had it on one of the slides, but we hired a search firm to help us go out and bring candidates in to apply for this. They do a pretty good vetting process of those candidates that they try to seek to get to apply for us. So, and also, as you said, the firing process, I will say, looking at some that may not have been fired, I would say there's some that have left jobs. When you look at the social media aspects of them, you understand what they're all about. Or if they had a specific incidents within their community, I mean, those that were in a position last summer, which all of them were that we're looking at, you know, how they reacted to their own community. I don't want to say they had their own riots, but some of them did, that I saw candidate profiles, and how they went and responded to it, and if they were all about tear gas and how that was viewed in the media and different things like that, didn't necessarily move up on my list. So you're able to do a lot of interviewing about candidates, about information you read about them before you sit down and start to have one-on-one conversations with them.
Thank you. One last question. How many finalists do you have now?
It is my intent to bring 4 finalists into the assessment center.
Reverend Carter?
Yes, sir. Thank you, Mr. Mayor. Thank you, Mr. Bach, for that presentation. I know this is complex, and I know there are a lot of things that come into play with this, and I know you are listening to the community to the extent that you can, and I know you're listening to other groups and entities, but in your heart of hearts, to what extent are you utilizing your gut feeling, because you know Wyandotte County, you know what we're dealing with, you know the landscape of the police department, sheriff's department, and so forth. To what extent are you using your gut feeling because you know what's best for Wyandotte County to choose those candidates that you're looking at?
Well, it's an interesting way to express that question. I guess that, you know, I mean, the input I'm getting probably helps to influence where I am. I think you have to find the right person that's the right fit for the current time. You have to assess it, what's going on with the department, what's going on with the community, what's going on at the time. And this has to be a person that fits right into my team of professionals. I will say it's probably gets underplayed a little bit as the job of the county administrator, but one of the biggest things I do is hire people that shape every department that we run. And when I do that, I want to make sure that it's somebody that fits into the mold of a character of somebody that works well with my team, that works well with other team members. And it has to be, they do have to have a good understanding. So when you say, yeah, I do have to feel right about somebody coming into it, but there's a reason, you know, you feel right about it, and that's the way they work through all the different intense things we put them through. When you listen to the way they answer questions, when you watch the way they engage and interact during these assessment centers, different characters will show, and you know, you can get a feel for that. And then And then when I listen to how other people will describe how that person reacted, and you'll get different reactions based on different people. It all goes into influencing that final decision. Thank you.
Sheriff Ash?
Yes, Doug, I'm wondering if you could share with us, how interested were people around the country in our position here? How many applicants did you have?
I would have probably expected more, though I didn't, because today is a very difficult time in law enforcement. My total candidate list was probably around 20, Sheriff, which I believe when I did this years ago, I think we had maybe double that, that came in and sought to go for this. And I think that's more consistent when you do go out and look outside. I mean, you have a few people that maybe aren't there, but it's a very difficult position to handle. The world is very critical of everything that a police chief does, not to mention all their officers, in watching over what's going on and coming in and we demand a lot of them. So it takes a certain kind of person, a certain kind of leader that's willing to put in for this. So
I would have hoped we would have had more interest as well, but I'm glad you shared that, because I think it's important for the task force to know that a lot of people are getting a little cautious of putting themselves in that position to put a target on themselves. And so that said, I think if you got 20, certainly those 20 were definitely interested in coming here, and that's what we want. That's what we need, somebody who really is interested, in coming here. And so good luck through the remainder of the process.
thank you. And I'll just say, I believe I have some very good candidates. Those people that are going to be in that assessment center are not, they will be able to perform at a very high level. And I hope that any one of the four that we end up bringing in could be a successful chief. It's finding the best one of that mix that could do it.
Mr. Smart, did you have a question? Curtis, did you have a question? You'd had your hand up.
Yes. So I was gonna say, has there ever been a case when if say there a lot of interest, but you find that, or maybe not just our department, but has there ever been a case where no one got selected and the process had to start over because there wasn't a candidate that really met the need of the area that they were going to serve? And would that be something that you would be willing to take into consideration if you found that the candidates, that though they're very interested, they didn't meet the criteria for what our county actually needs?
Yeah, I haven't been part of a process where that's happened. And for this kind of position, I've had some professional positions where it's happened where I've had to stop and start the process over, or when I've gone through recruitment and looked at the applicants coming in that determined that I needed to extend the recruiting period a little bit longer. When I saw the numbers, I thought about it here. But then in taking a look at the candidates and the quality of the candidates that we had into the process, I felt good in moving forward that I'd had the quality of what I was after. So I continued on. So yeah, if I got my numbers initially, looked at them and felt like, oh boy, I've only got even if I felt like, boy, I got two really great ones, I probably would have stopped. In this case, I had the majority of these candidates were highly qualified to come in and do it. There's always a couple in the mix that somebody's maybe stretching or yeah, there's somebody you look at a quick profile on them and you go, no, I don't think so. But, you know, and that kind of goes back to the earlier question, like Dr. Hill put out there. You see where they have been and some of the situations around the other thing. You go, we have great criteria on them, but they're not somebody that we're going to bring in and put into our community with what's happened where they were somewhere else. So, yeah, I pride myself on making the right decision when we bring somebody in. So if I don't feel like I've got the right people to work with, I would start it, but that was not the case.
Thank you.
Monsignor Swetland?
Doug, you may have mentioned this and I may have missed it, but I was just looking at some sample contracts that usually a chief is brought in for a certain term or initial contract. Are you looking for a 5-year, 3-year? Do you have something in mind as far as the initial contract term?
Yeah, one, I don't do contracts with the chief. I've never done that before in our government. I don't know that there's a need to do it. Though I will say that is a time frame that I hold in talking to a chief, that I look for them to commit to me to stay here about 5 years, or at least to that. Longer than that would be great. I think in today's environment, actually 5 years has become a very long time, particularly in a community that we're hard on it. Chief York's doing a great job. He has a good demeanor, and even as interim chief as he's done, but that it's not a hard contract that I'll put in place and say sign here or else. But it will be one that I'll look for that person to have the expectation that they'll stay that long and lead our department.
Thank you.
Mayor, there are persons that are watching that are wanting to comment, and I just wanted to add, if you have a comment, that you can email us at cprtaskforce@ycokck.org, cprtaskforce@ycokck.org. Thanks for letting me interrupt there.
Thank you. Yes, Reverend Carter?
Yes, let me ask a quick question. Mr. Bach, you say you whittled the list down from about 20 candidates down to 4. Can I ask what was some of the criteria that caused the 16 that you didn't keep, that caused you not to select them? Is there's some particular something that sticks out or stands out as relates to those, as opposed to the 4 candidates that you did choose?
Okay, and there's a lot of things that go into it. Coming down to this part, Reverend, I mean, initially you start to go through and look at those candidates and do what is their, one, you have to feel like you have somebody that has professional ability, professional background and criteria. I mean, that's one of the number one things you're going through and looking at that resume. Where they've worked, the kind of community they've worked in, what's the diversity if they didn't. Some candidates have worked in larger cities, some are similar size, you know. Obviously we had some internal candidates that came into the mix, and you evaluate where, when you look at those, how close they are to making that next step to the chief, what kind of decisions they've been able to make. So you go through that evaluation. Then asking various questions, ask questions about, you know, how they engage with the community, you know, how they see this, or what their thoughts are on different things of transparency. You go through areas of diversity issues, working in turbulent situations, recruitment, and do that from a series. Like I said, we do that on the video side, see how they perform, and then come into the virtual side, or not virtual. It just happened to be virtual because that's the environment we're in today, to ask those questions, see how they respond to it, get a comfort level with it. I do not do this in isolation as one person. I had a smaller committee with me of some department heads that go through and do the narrowing when we look at the resume list, and then look at the first, then I bring in a different group that helps me look at it and sits down and does the panel interview with it. So I get their input. along with what I think. And when they give me their input and I see how that shakes out with what I'm doing, and that ultimately takes me down to that smaller group. And I'll say this too, a lot of the questions and areas of emphasis that we put in were based on a lot of the community feedback to make sure we were covering the areas that I went through when I was, had that input coming in from community from the survey, or in meetings with the community groups. And I'll tell you another area that I asked questions about and get into them was how they handle discipline and how they work through that. We are a union shop, so understanding how somebody works with labor unions is important. When I met with the police officers, the national narrative is out there that people need to be more strict with the officers, that there's not enough discipline or not enough consequence for their actions that are in place. I met with 40 or 50 of our police officers directly, had them in rooms. The number one issue they had was that we are a very strict department, that our discipline level is higher than that of any of the surrounding departments. When they do something, the consequence is greater than it should be. They did comparisons over to KCMO, to things that came about that they felt like that department, boy, they're going to get rewarded for their action, where they felt like they'd get a week off in our department, So there's different parts that you got to take from that. I think I probably had a higher percentage of some of our officers that came in to meet with me that probably had some, a little bit disgruntled with the way management had treated them or worked through some things, and they were good about vetting that. So that allows you to think that in, but bring that into consideration. All those meetings though that I held with those groups were before everything with George Floyd, and then what you heard come out of the national narrative. But I just as I go back through all my notes and look at those comparisons, it's really interesting to understand how our department certainly makes sure that we're on top of where we are and what our officers' actions are.
Okay, thank you. And again, if you have questions, if you're an attendee and you have questions, please email. We will get back to you with answers to that. Before we thank you, Mr. Bach, for that update, and we will be looking forward to the process moving forward.
All right, thanks for having me today, Mayor.
Thank you.
And I do want to say again, I do appreciate the input that you all put from this task force and the information. As I said, I listened to the session. I wasn't there the night. There was one meeting I'd missed this year when the task force presented, but we video record everything, and I listened into it from virtual, and then I've gone back through it to get the input that each one of you did in your presentations that evening about areas of high concern. So that would be considered within what I was doing as I went through this process.
Mayor, I think I saw Max's hand waving, and Dr. Hill, did you have another question, or did we?
Oh, maybe so. I'm sorry.
One quick question,
Yeah.
Mr. Bach. You mentioned the Blue Ribbon Committee. I think you might have said how many's in there, but I would also like to know how did one be selected to be on that Blue Ribbon Committee?
Well, it's probably from involvement that people have in the community, different things that they do. I try to do a cross section across the community, look at professionals, community people, culturally how they're involved, try to just factor in various things that come about and take a long list of people and then narrow it down to probably about 15 or 20 that fall on that final list. And I will get the input of the mayor and maybe some of the commissioners about their thoughts on it. That's an area where they're very strong about, and try to build that list from there. I will try to have a couple members from this task force on it as well.
Mr. Mendoza, I think I missed you when we did the introductions, Max.
Hey, yes, I'm Max Mendoza, Executive Director of Heartland 180. I was actually came in as an attendee, and then it finally brought me over to the rest of you all. But I didn't have anything, but I noticed Curtis has been waiting very patiently to ask his question. So I want to make sure that Curtis gets his opportunity.
Thank you. Yep, I saw him wave. Mr. Smart.
Thank you, Mr. Mendoza. Great name. Yep. So my question was, are there any internal applicants as far as within the department who have decided to extend themselves for this role, for this position? And if so, would it be okay if you released how many? Like, you don't have to give their names, but maybe a number of how many?
Yes, we had internal applicants, and I'll probably just leave it at that.
Okay.
And Chief York is not one of them.
Now I have my hands up, Mayor. Doug, as relates to cultural competency, how big of a part did that play in your selection process up to this point?
It's a big part of what it is. I mean, it's one that probably I'll be able to get more information out as we move through the assessment center and do more one-on-one type interviews with them. It's something you can look at and you can get a feel for based on the communities they've been in. So that if you haven't been in a community with any diversity, it doesn't necessarily put you in a place of not being able to understand that. And I use one of the best examples. We had Chief Helen Hansen come in here and work in our department for a year, and I think she was people thought the world of her. She was a chief in Lenexa, Kansas, not a community known for a lot of diversity, not a lot of social inequities going on there either. Yet she was able to relate and do quite well in our community. So I didn't just look at a candidate and say, boy, across the board, you're from a candidate or community that doesn't have the same diversity level as what we have, and your exposure to it and how you engage. But it is a question of understanding the backgrounds of people and ask those questions. When you ask somebody about how they engage with different sectors, different groups in society, different parts, you can get a lot from that answer. And not everybody recognizes a lot of people will come in with an answer that they just only see it from their perspective. And that comes through in those answers.
Thanks. I mean, I know that you already know that that's going to be a big question, and I just wanted the public to be able to hear, how important of issue this is going to be as it relates to your process of making the decision there. Thank you. Appreciate it, Doug.
Yeah.
Okay, I do think that's it. Questions from the task force. Thank you again, Mr. Bach.
Thank you, Mayor.
Okay, next up, we have a presentation by Casey Meyer, City Attorney, Commissioner Townsend, Gail Townsend, and Dr. Hill, you may correct me. I think you may have asked also for we might dive into this notion of qualified immunity, what it is and what it is not. And so I've asked legal to prepare a presentation for us. I think it'll clarify quite a bit of what qualified immunity is and what it is not. And so I'll pass it on now to Casey Meyer from our legal team.
All right. Can you guys see my screen?
Yes, we can.
Yes.
Okay. Okay. So
like Mayor said, my name is Casey Meyer. I'm an attorney here in the Unified Government Legal Department, and I'm the legal advisor for the Kansas City, Kansas Police Department. I think some of you are familiar with me because I have participated in a training with some of you a couple months ago. But as I go through my PowerPoint, feel free to interrupt me and ask me questions. But I will also give, there's going to be plenty of opportunity for you to ask questions at the end too. Okay, so qualified immunity is a judicially created defense in federal civil lawsuits. I think it's important to note that it's a defense that applies to all public employees, not just law enforcement. I understand that usually when we hear about it, it's in the context of being applied in a use of force for an officer, but it actually applies or may apply as a defense for all public employees. And that is only if the employee is acting in their capacity as a public employee. Okay. When I say it's a judicially created offense, so that means it's not created by statute. It wasn't created by Congress. It is basically created or was created by case law in federal court. And the first case regarding qualified immunity came out in 1967. So you can imagine that there's been a lot of case law since 1967, kind of tweaking and fine tuning how the defense is applied. Okay, so
Casey, if you don't mind.
Mm-hmm.
So I just want to emphasize, I think this is a really crucial piece to understand the rest. This, again, there is no law, there's not in the Constitution. It is defensible within the Constitution, but it is not in the Constitution. It was not created by any legislative act, Congress. There is no law. This is simply what the courts have found within the Constitution, within case law, to say that basically public employees, when they are doing their job within the constraints of their job, have protection, that they have immunity, but it's qualified. So to be clear, this is not created by the state. It is not created by the federal government. It is not created by the county. It is also not in union contracts.
Correct. That's right. So it's not, this doesn't apply here because of a union contract or anything. And again, this is a federal civil defense. And when, Mayor, you said that it will apply or may apply to a public employee in their duty, it has to pass the court's muster. The court is analyzing the facts of each case and will determine if it applies based on the facts of that case. So I think that sometimes people think it's an automatic immunity or that it prevents someone from bringing a lawsuit from the get-go, but that's not correct. Somebody can bring a civil lawsuit and make a federal constitutional claim, and then the defendant would try to assert the defense of qualified immunity. And the court will analyze whether or not that defense will apply based on the specific facts of that case. If the court determines that it applies in that case, then it will result in dismissal of that specific claim. Sometimes, if there are multiple claims in a case, maybe only one of those claims will be dismissed because qualified immunity applies. But it's a very fact-specific analysis in each case. Another important thing to remember is that the court uses the same analysis in every single one of these. Number one, is there a constitutional violation? And if there was a constitutional violation, was there clearly established law that would have allowed an officer in that officer's situation to have known that it was a clearly established law? So I'll get into that a little bit further here in a second. Okay, further with jurisdiction. I just want to reiterate that this does not apply to criminal law at all. So it does not prohibit criminal prosecution. An officer might get qualified immunity and be able to get out of a civil case, but that doesn't mean they can't be charged criminally. Those are two separate things. And I've already explained that qualified immunity is not absolute immunity. Absolute immunity is the kind of immunity that judges and prosecutors have. And that's basically the immunity where you can't get sued. That is not this. And again, I've said this multiple times, it only applies to federal constitutional claims. This is not something that applies to claims that are brought in the state of Kansas. So we are in the 10th Circuit, and that matters because the 10th Circuit is the law that applies to us. So we don't care what's happening in the 9th Circuit. And in fact, the 9th Circuit frequently makes different rulings than our 10th Circuit courts of appeals do. So we use the rulings and the decisions that our Court of Appeals in the 10th Circuit make when we're analyzing what rules and laws apply here in Kansas. And so I provided a nice little map there. And then also the US Supreme Court, when the US Supreme Court makes a decision, then their decision is going to supersede any lower court decision. So, you know, the 10th Circuit might say something, and if it goes up for review by the US Supreme Court and the US Supreme Court believes differently, they can overrule the 10th Circuit Court of Appeals. And that happens sometimes. And then we would apply whatever the US Supreme Court said. Okay, so like I said, and I reiterate this because any of you can get on Google, and if there's a case that you see in the news, I would encourage you, instead of just taking whatever the news says happened, Google the case, and you can pull up any case and you can read it and you can get the facts yourself. But the court always analyzes it the same way over and over again. So I also want to make sure everybody understands that I know that usually we think about qualified immunity in the context of use of force, but it applies to all constitutional violations. And so I've included a list of frequent potential constitutional claims that police might come up against. So obviously, you know, First Amendment, your freedom of speech, that's people's ability to protest and gather. And so people might bring a constitutional claim against an officer for impeding their ability to assemble or protest. Second Amendment, we all know what the Second Amendment is. Fifth and Sixth Amendments, this is your right to double jeopardy, Miranda, due process. So maybe a constitutional claim could be brought against an officer for maybe failure to provide Miranda, which resulted in that person getting charged with something and spending some time in jail. Then the 8th and 14th Amendments are amendments that address excessive bail and cruel and unusual punishment. But I know what everybody's most interested in, and that's the 4th Amendment. And most case law addresses 4th Amendment, and that is our right to privacy and our right to be free from unreasonable searches and unreasonable seizures. And so those are the kinds of cases that deal with unlawful arrests, excessive uses of force, malicious prosecution, and maybe unreasonable searches. So use of force under the 4th Amendment is always analyzed with, currently, is analyzed using what is called the Graham factors. Graham was a US Supreme Court case that came out in 1989. And it basically establishes kind of a test that the court uses to analyze whether or not a use of force might be excessive. And the 3 factors they consider are the severity of crime that the suspect may have committed. 2, whether the suspect poses an immediate threat to the safety of the officers or others. And 3, whether the suspect is actively resisting arrest or attempted to evade arrest by flight. Okay, so the next case, I'm just highlighting this number 2 prong because there's a lot of case law that says this second prong is the most important prong. Well, in the reasonableness standard, I think a lot of people talk about too. So this also pops up in all the case law. So the reasonableness of a particular use of force must be judged from the perspective of a reasonable officer on the scene rather than with the 20/20 vision of hindsight. I guarantee you, if you pull use of force cases, you're going to find that holding in almost every single one of them. The court reiterates that every time, because frequently facts come to light after the use of force that the officer wasn't aware of at the time, and the court understands that to make a correct assessment, we have to view it from the officer's point of view at the time the use of force was made. Okay. Deadly force. So this is that second prong of those grand factors I was talking about. Tennessee v. Garner. That case is also cited in probably, I would say 80 to 90 use of force cases that have to do with deadly force. And the holding in that case is that deadly force may not be used unless it is necessary to prevent the escape and the officer has probable cause to believe that the suspect poses a significant threat of death or serious physical injury to the officer or to other people.
Yeah, and I think the more we can say we have the entire health equity task force team and the subcommittees involved in that brainstorming and idea generation process, then I think the more true it is to our.
We have someone who's not muted.
Okay, so the case law is important because that's what most legal advisors, most attorneys use to train our officers. So we train all of our officers annually, and I pull Susan and I, Susan for the sheriff's department and I for the police department, we pull all these cases that address these constitutional rights from the past. We usually go back 1 year because we're doing it annually. And so really the easiest way to explain it is by going through and reviewing cases. For purposes of this and our limited time, I'm not going to go into a lot of detail on each of these, but I think these are some good cases that highlight different uses of force, and they basically create rules that we can rely on and that our officers can rely on in knowing what type of force would be reasonable in certain situations. And so I think I'll just hit on 3 here that I think are pretty good at explaining it. So Casella v. Hughes is a Supreme Court case from 2018. And what happened is law enforcement responded to a call from a citizen that observed a woman, later identified as Hughes, with a large knife hacking a tree. So police responded to that area. The concerned citizen waved down the officers and said, she's coming out of that house over there. I saw her earlier. She has very erratic behavior. And so the police responded to that general location. When they arrived in that location, they saw another woman that was standing in the driveway. That person was not Hughes. Her name was Sharon Chadwick. The police, at this time, there's 3 police officers. They start walking towards Sharon Chadwick, and they are separated by a chain link fence. While they start talking to Miss Chadwick, Miss Hughes comes out of the house with her very large kitchen knife, and she walks directly toward Miss Chadwick, and she stands within 6 feet of her. Okay, so the officers are separated from the person with the knife, right? And they're separated by a chain link fence. And she has a knife, she doesn't have a firearm. So all these facts are important in the court's analysis of what kind of use of force might be acceptable. Well, what happened here is all three officers believed that Miss Chadwick was in danger. They made commands for Miss Hughes to drop the knife several times. And while Miss Hughes remained calm, she was unresponsive. She didn't acknowledge the officer's presence, and she didn't drop the knife. So then one of the officers, Officer Casella, fired at Miss Hughes and struck her. He fired at her 4 times, struck her, and she had injuries, but they were not life-threatening. So she brings a lawsuit, and she claims a constitutional violation under the 4th Amendment for excessive force. And what our Supreme Court held was that under these circumstances, because we know under Tennessee v. Garner, where the officer has probable cause to believe that the suspect poses a threat of serious physical harm either to the officer or others, then it's not constitutionally unreasonable to prevent escape by using deadly force. So in this case that came out in 2018, the U.S. Supreme Court determined that that was a reasonable use of force, and the officer in that case was granted qualified immunity on that claim. Okay, now what the officers didn't know at the time is, and I think we can probably tell from the facts, that she was hacking at a tree. She suffered from some severe mental illness. And another fact that they didn't know was that Miss Chadwick was actually a roommate, and Miss Chadwick was not in fear of her life at all. But when you review the facts without 2020 hindsight from the information that the officers had at the time, that's what the court considered in making that decision. Another case that I kind of like that came out of the 10th Circuit is Mccoy V Myers. That actually happened here in Kansas, in Hutchinson, Kansas. Police responded to a call from a motel where Mr. McCoy was alleged to have hostages, and the caller also said he was armed. So police responded. They knocked on the door. He didn't respond to the door. So they called their emergency response team to enter the room. And this was actually 5 hours later. So they were trying to be really patient. But there was also information that there was an infant in the motel room as well. So they entered the motel room, and Mr. McCoy, and there's evidence that supports this, and Mr. McCoy agrees that this actually happened as well, that he pointed his firearm at the officers when they entered the motel room, and he was also pointing it at his sister, who was with him this entire time. So he was kind of pointing his gun back and forth between the officers and her. Well, the officers don't use force at that point. They tell him to drop the gun. He drops his gun. They remove his sister and the infants, and then when they're taking him into custody or arresting him, one of the officers believes that he tries to reach for his gun. So at that time, they place him in a carotid restraint, and they start hitting him in his back and his neck and his shoulders. And the carotid restraint causes him to lose consciousness, which in law enforcement training, they're aware that that happens. So he loses consciousness, and while he's unconscious, they zip tie his legs and they handcuff him behind his back, and then they move him to a sitting position. Okay, so then he wakes up, and another officer comes in, and even though his legs are zip tied and his handcuffs are behind his back, another officer starts striking him and hits him about 10 more times while he's already handcuffed, and then applies a second carotid restraint. which results in his loss of consciousness. Okay, so he had some injuries, they were fairly minor. He brings a lawsuit against those officers alleging excessive force, and he brings two claims. One for the use of force for that first carotid restraint, and then a second one. Well, how our 10th Circuit reviewed that is they split them up, and they analyzed it from, okay, well, pre-restraint, Mr. Mccoy is not yet subdued, right? The officers believe that he still had the ability to reach for their firearm. He was not yet handcuffed. He didn't have any zip ties on his feet. And so they found that that use of force was reasonable, and that there was no clearly established law that would have told officers that at that point, that level of force was not allowed. So that claim, that first one, they were granted qualified immunity. The second claim, where Mr. Mccoy was already restrained and it was handcuffed, that use of force, when they started hitting him and applied a second carotid restraint, they said, well, that's a constitutional violation, and we have clearly established law on that because he was no longer a threat. And so on that claim, they were denied qualified immunity, and that case went on. But it's important because those provide us rules that we know, okay, well, once somebody is subdued and handcuffed, then we know that we are not, our officers are not allowed to use that level of force, or it's going to be a constitutional violation if they do. Okay. One more. So Emmett v. Armstrong. So this one is, I feel like something that could happen frequently. So Emmett, so police respond to a party at the Elk Lodge in Wyoming, and they were actually responding to a call of a fight. So they believed they were investigating a fight that had broken out there. Unbeknownst to them, there had actually been no fight, and this was just a big old mistake. But they make contact with a witness at the scene who identifies Mr. Emmett as one of the people who were engaged in fighting. So the deputy tries to make contact with him, and he starts running away, and the deputy tackles him. And while he's on the ground, Emmett's on his back looking up, and there's body cam video of this, so this is where they're getting their facts. The court says he appears relaxed. Any attempt to flight appeared to have dissipated. And so the deputy then says, or tells him to roll over so he can cuff him. And Emmett starts laughing at the deputy and then does not roll over. So then the deputy immediately says, I'm going to tase you. And before he ends his statement about I'm going to tase you, he tases him. He tases him one time in the stomach. Okay, so Emmett has minor injuries, but he sues in federal court, makes a federal claim for excessive force. And the court analyzes it like they always do. So is there a constitutional violation, and is there clearly established law? So if you guys apply the Graham factors, severity of the crime. Well, the severity of the crime that the deputy was investigating at that point was just a municipal ordinance violation. It was a misdemeanor, and it was only punishable by a fine. There's no jail time. So the severity of the crime weighs in favor of the plaintiff, Emmett. The next prong, whether the suspect posed an immediate threat to the safety of the officer or others, the court said also weighed in favor of Emmett because they had determined from the body cam he was on his back. He was also had no weapons. He was not armed in any way. And there was no evidence that he was going to flee. The third prong was he actively resisting or fleeing at the time? Again, that one weighs in favor of the plaintiff. So the court said, okay, all these factors weigh in favor of the plaintiff. They all support minimal use of force. Using a taser in this situation is not a minimal use of force. In addition, it's important that if you're going to tase someone, you need to notify them that you're going to tase them and give them an opportunity to comply. If you're going to tell them that you're going to tase them, but don't give them an opportunity to comply, well, then what's the point? And so in this case, he said, I'm going to tase you, and kind of simultaneously tase him. So based on these facts, they determined that that was a constitutional violation, and also that there's a lot of case law that says that that's clearly established. So that deputy was not granted qualified immunity in that case. I could go on, but I know that we're limited on time. So I want to make sure to cover indemnification. So qualified immunity is a defense that we would assert in a case to try to get a claim dismissed. But regardless of what happens in that, there's a state statute, and most states have a statute that requires indemnification or defense of their employees. And the state of Kansas is no different. We have a statute that requires indemnification against damages or injury proximately caused by an act or omission of an employee while acting within the scope of his or her employment. Want to make it clear that this would not include punitive damages. So punitive damages are damages that a jury may award for maybe some willful or egregious acts in an effort to punish the individual officer. The statute doesn't require the city to indemnify punitive damages. Also, the statute requires that the employee cooperate in good faith in the defense if we are going to provide them a defense and indemnify them. So again, that's statutory. That is not included in any FOP contract or contract. That's a statutory requirement. And again, most states have that. Are there any questions?
Thank you, Casey. Yes, are there any questions? Just raise your hand. Yes, Monsignor Swetland.
I just want to make sure that I'm stating this right. So for our police force, the Kansas City, Kansas Police Department, looking at that entity, I know there's sheriff and there's others, but I'm just looking at that for now, for the sake of this question. In the use of deadly force or any other use of force, as they're trained annually, if they follow the Kansas City, Kansas Police Department rules and regulations and procedures, and that includes what I call the rules of engagement, but have different names in different police forces established by the department, then those individual officers or group of officers have qualified immunity. Is that correct?
Well, it should work that way. I mean, there's always a potential, and our policies are up to date, but you can also sue if your policies aren't, you might have good policies, but if they're not applied correctly by the officer, or if the training wasn't done correctly, then you might have some issues with that. But yes, generally, if they're following our policy, then based on the law, because our policies are based on the law, they would likely be granted qualified immunity.
But again, that would be up for the court to decide.
Right.
Yeah. Well, and again, the court doesn't actually, they're not going to read our policy and say, well, the officer complied with the department policy, therefore qualified immunity applies. The court is only going to analyze how the law applies to the facts of the case.
Well,
And
Casey,
so-
as a good lawyer, you took me to where I was getting, that our policies and procedures are vetted in such a way that we assure as best we can that they conform to that law, not only to protect our officers, but protect our county from, having suits lodged against it.
Exactly. So that's why I review case law every week to make sure we're all good. And then, although we're training the police once a year, if there's anything that needs to be changed in policy, we do that more immediately if need be. And also, our command staff can go to roll calls and update in that way too. Because we understand, we wouldn't want them to wait a whole year if there's a case that comes out that would affect how we should be responding to a situation.
So would you look at those policies and procedures and rules of engagement for that as the attorney or someone in your office? Or is that just part of the training that the senior leadership would have already so that they know what policies and procedures to put in place?
Chief, I don't know if you want to talk about that, but there's a policy review team, and I'm included in the policy review team, and we review those if anything in the law changes. Like I said, if there's something that changes, I notify command staff and chief, and they're always very quickly responsive in bringing that issue to the table for policy review and make adjustments as needed.
Casey, did you ask Chief if he had anything to add to that?
I did, but he might not have anything to add.
No, I don't really have anything to add, Mayor and Monsignor. I mean, Casey summed it up pretty well. We meet several times a month to discuss policies, to update policies, and we always get, obviously Casey's part of that. It's called policy review, and we do it, several times a month to tweak and to improve upon our policies. And when Casey comes upon something that needs to be changed, we change it. We get it out to the officers as soon as we can.
Yeah. Some of that you had told us when we went through the academy, but I just wanted maybe people watching and concerned about this to hear that, because I think it's important that everybody know that there's this constant feedback loop to make sure that the policies and procedures meet the highest standards, both legally and morally, because that's what we need to have them. And that's what I was just making sure that was clear. Thank you.
I just want to make a comment at this point. I think it was very helpful to bring this topic to the task force, because I think there is some confusion. I mean, this has cleared up a lot of confusion on my part, but I think there's some confusion that qualified immunity somehow provides a license to kill to police, to do whatever they want, that there's no recourse, and that police officers, law enforcement officers go into the field thinking that they are untouchable. And in fact, it's not that at all, that this is within very specific grounds or constraints. And you have to abide by constitutional rights, and you have to abide by policies and your training, and all those need to be in alignment. And that it is, if you abuse any of that, you're subject to lawsuits.
Right. And I
Dr.
think,
Hill?
Mayor, Mr. Mayor, that's why I sound like a broken record a little bit here, but that's why I think it's so important that the public and everyone, we agree as a community what those rules of engagement and policies and procedures are, and that they are vetted both legally and morally to reflect those standards that we expect. And that's a big part, I think, of what we've been talking about over these last 8 meetings, is the need for that to be agreed to by the community. And I think that's why that review that's very transparent is so important, so that there's community understanding.
Yeah. Thank you. Dr. Hill?
Thank you, Casey. Good job. One of the things you mentioned early on, which I'm guilty of, you said go beyond what the news says and go to the cases. So you said we can just Google the case?
Yeah,
and-
there are actually a lot of resources that, if I can go back. So like if you wanted to Google a case, this is the case site. You would just like want to copy and paste the whole case site, and you could put it in your Google search, and then there's a lot of sites that have the entire opinion. Just like I read and review, it has the whole thing, and it outlines all the facts, it outlines all the law that applies, and then it provides the court's decision. And you know, I think it's fun to do, but I think that when you do that, if you do it enough, you start seeing the trend and how that they apply the law very consistently. And then all of a sudden, if there's something new, well, then we all kind of know, oh, they did it a little different in this one.
So for instance, if there is a case, we would know it's, you know, we would just know that person's name, for instance, Evelyn Hill. But you know, we wouldn't know if it was the 10th Circuit Court. We wouldn't know that, but we would just know the name, just the average citizen. So would you just Google in the name and just ask for a case review that way?
Well, you could. I mean, if you knew that the case was brought in the state of Kansas in federal court, then you would know for sure it's in the 10th Circuit. But yeah, if you Google, if you know the plaintiff was Casey Meyer, then if you Google that and you kind of know the facts, well, then hopefully they give you, maybe some article will give you a case site, and then you can just pull that case site and look it up yourself.
I see. Okay. And then you mentioned earlier, you showed us like the Fourth Amendment, which, you know, explains individual rights. So can you explain how that plays into action with the no-knock warrants? So, you know, one of the questions I asked you when you did when we were at the police department and we did the assimilation that Saturday, I asked you about the Brianna Taylor case. And could you just kind of give us how this all fits in? Because the average citizen may not understand. I like myself, I didn't understand how the no-knock warrants are there. The individual has the right to have their, you know, it's a private resident, but they have the warrant, so the police do have access. So just kind of tie all that in to help us understand.
Okay, well, so that is in a different circuit, right? So I'm not quite sure about what exactly the clearly established law is in that circuit, but let's talk about Kansas. So when you're considering clearly established law, you're going to use both the statutes that apply in that state as well as the federal law. So in Kansas, as you know, we have a statute that allows us to defend our home. Okay, so there's a presumption also built into the statute that if someone enters your home and you don't know who they are, that the use of deadly force would be reasonable under our statute. Okay, so but also in Kansas, we have case law that says in some situations it's okay to have no-knock warrants. Now, no-knock warrants are supposed to be used very sparingly. They're supposed to be for officer safety issues. And it's my understanding our department doesn't really use them anymore and has used them infrequently at best. Okay, so we know that you can get a no-knock warrant though from a search warrant, and you would need a search warrant to be able to go into somebody's house because that's under the Fourth Amendment, you know, for a reasonable search. You have to have probable cause and a warrant signed by a judge. So if you're coming to the house and you don't announce your appearance, and you enter the residence and the people inside aren't aware who it is, well, the danger in that is those people are able to use force against the entrance. And if they, if they kill a police officer who didn't announce his or her appearance, that's an issue, right? They didn't announce their appearance, so the people didn't know they're law enforcement officers. So then there's really no way to charge that as a crime. That's one issue. But also, the court is pretty limiting in when law enforcement can use no knock warrants. But it's legal in some situations.
Okay, here's my last question for right now. Can you explain one more time? You mentioned the reasonableness standard. Can you explain that again? I totally missed out on what that really meant.
Right. So that's just kind of like okay. So let me go back. Well, you know what? One way to explain this is there's a case that came out recently in the U.S. Supreme Court. It's actually, I had it on my list of things that you might want to look up. It's that Taylor V Rioja case. Well, that's not a Fourth Amendment case. That's actually an Eighth Amendment cruel and unusual punishment case where a prisoner was in jail for about 6 days, and the conditions of his jail cell were really, really horrible. There was evidence that there was fecal matter all over the floor of this cell, all over the walls. The drain wouldn't drain. It was clogged up with fecal matter. So the prisoner, he tried to hold off on using the bathroom, but when he used the bathroom, it caused the drain to overflow, and then there was even more fecal matter, and also frigid. Uh-oh. Can you guys hear me?
Yes.
Okay. Well, you don't need to see me. You can just hear me. Okay. So the Fifth Circuit, so this happened in Texas. So he makes a claim, he files a federal suit under the Eighth Amendment for unusual or cruel and unusual punishment. And the Fifth Circuit Court of Appeals said, well, it's clear that this is a constitutional violation, but because there's not clearly established law, we're going to grant them qualified immunity. Well, very, very rarely will this happen. The U.S. Supreme Court took this up for review. And really, normally, they do their whole, is it a constitutional violation? And there's clearly established law. But in this one, the court said that the conditions of the cell were so egregious that there is no way a reasonable officer in these deputies' positions would have ever believed that that was appropriate under the Constitution. And although here this reasonableness standard is under a particular use of force, you still apply what would a reasonable or objectively reasonable officer who's also trained, how would they respond in this situation? And so they apply the reasonableness standard in that case. As far as it goes with use of force, it's pretty similar. It's just that, again, it has to be a reasonably trained officer in that officer's situation. How would a trained officer in this officer situation normally react based on their training and experience? So you can't take like some outlier and call that officer's actions reasonable. So I know that's a weird way. I didn't probably explain it very well, but it works in conjunction with Graham factors if you're talking about use of force.
Yes, Reverend Carter, thank you.
Yes, Mr. Mayor, and I apologize. I don't really have a question, but I feel like I would be derelict in my duty if I didn't say this. I want to commend Sister Meyer and Monsignor Swetland and the mayor for really exposing the misinformation that often plagues our community. We hear the word immunity and we automatically think that's a way for somebody to get away with something. But Ms. Meyer, you have really, by the examples you gave, even though some of them were a little far-fetched, by the examples you gave, you made it clear that this is not a way for people to get away with, as the mayor said, murder. And I think, again, these kinds of conversations need to be had when there's not a crisis, because I think our community will respond positively to good information, but we have not yet created the platform for that information to be shared on a regular basis. And again, don't ask me what regular means. I know that's an objective term, but I think that's what needs to happen. And as a part of our protocols moving forward, I would hope that these kind of gray areas would be explored and explained so that the community has at least here's your word, Ms. Meyer, a reasonable understanding of what's involved. But thank you to all of you for dealing with this. I'm done, Mr. Mayor.
Yeah, thank you, Reverend Carter. I think that's you're spot on. In my opinion, I felt this was very informative to me. It's just so easy, lawyers deal with language, and the language means something, and very precise, and it's very controlling. And this is why it's so important to really bring this forward. And I think there are other topics like that. We've found, I think, consistently throughout the meetings of the task force that I've learned just so much. I don't want to speak for everybody else, but I know I have learned a tremendous amount and realize how much more I have to learn. Are there any other questions or comments for Casey?
I just want to say thank you again. I thought it was a good presentation, and it helped me as a citizen just understanding a little bit better. So thank you again.
Thank you. I appreciate that. And if you ever need a case citation, I'm happy to try to send you one if you need help finding something.
Well, we'll do that, though. I've learned don't really ever give the microphone to a lawyer. Just all right. Well, that concludes. Again, anybody who's attending, please send emails. We will respond to those, get you the right answer. And again, if you have other topics that you would like to see us explore, please send those in, and we will discuss as a task force and try to accommodate those. I want to thank all the members of the task force. Thank you so much for attending. Again, appreciate the time, the energy, your openness, your honesty, your commitment to this. I believe it's been very effective. Thank you and good evening.